Hey, my name is Matt Reardon. I am back live. I haven't done a podcast here in a while. I've got some new good information I need to get out. I need to share. Okay. In my hand, I've got a newly filed petition from Phyllis Crowder. It doesn't stop. It never stops. Okay. It's not enough for her to have robbed me of the majority of my daughter's life so far based on lies. What really irks me the most, what really grinds my gears far beyond that, is the county, the sheriff department, just letting her get away with it. Just almost helping, assisting in any way possible. And what they're trying to do is they're steadily trying to mix courts. They're trying to, here you have in justice court right now, you have them doing their damnedest to try to criminalize the family court matter. And honestly, it should have been criminal from the start. They just need to switch the damn seats around. Look at the evidence right in front of them. It's right here, okay? Couldn't get any more corrupt. Also have discovery, or what fellow J. Kane, the Lafayette County prosecutor, considers to be discovery. I'm going to show you what my discovery request was. In fact, I actually just got in touch with Jill earlier at the Justice Court clerk. Asked her to please email over a stamped copy, a on-file copy. They have. I've got mine. It's just everything is stacked up so much damn paperwork between so many, courts. And here I am fighting one by one off, haven't gotten shit for representation, especially with my court-appointed attorney for the first time on Friday, and that's like a week and a half before trial, 9 charges that I think it's absolutely necessary to understand the whole background of everything. If you can't get that, you can't have trial. And I'm not getting any cooperation with discovery under Rule 1910. For withholding evidence. What do you do? In the Chancery Court of Lafayette County, Mississippi, Matthew Oliver Reardon, your plaintiff, versus Phyllis Marie Crowder Kester, the defendant. This is the amended petition for citation of contempt and modification of child support agreement. Comes now, the plaintiff, Matthew Oliver Reardon, files his petition for citation of civil and criminal contempt and petition for modification of child support obligations against the defendant, Phyllis Crowder Kester. In support thereof, your petitioner would respectfully show unto the court the following. This court has personal and subject matter jurisdiction in the matter. That the defendant, Phyllis Crowder Kester, is an adult resident citizen of Lafayette County, Mississippi, and may be served with process at her residence in Lafayette County or wherever she may be found. 3. That on March 23, 2021, this court entered a temporary order regarding child visitation, a true and correct copy of which is attached hereto as Exhibit A. 4. The defendant abruptly ceased communication between the plaintiff and his minor child on or around June 5, 2021. 5. The plaintiff states conduct of the defendant has now far surpassed self-assuming the role of judge, jury, and executioner, and that by now the defendant should certainly have the forefront knowledge to not override a signed order of this court or any court for that matter. 6. that defendant's legal counsel most certainly had an ethical obligation to advise defendant against withholding all visitation, contact, and communication between the plaintiff and his minor child. Yet for the majority of her life, she has experienced forced separation by way of manipulation, false and frivolous legal claims that lack all substantive evidence, adding extra burden to the court docket and expending county tax dollars through one way or the other. 7. The false claims that have been asserted by the defendant and her attorney have met and exceeded the threshold required for slander, defamation of character, abuse of process, and malicious prosecution. 8. The plaintiff would demonstrate to this court by admission on a recorded phone call that plaintiff holds in his possession. Defendant admitted to conspiring with her present husband in an obnoxious attempt to falsely accuse the plaintiff of raping her on November 28, 2018. As a result of her criminal actions, Olive Branch Police Department filed a misdemeanor charge against the defendant and sought a warrant for her arrest in or around January of 2019 for making a false report of rape. 9. As a result of the defendant's contumacious actions, the plaintiff has in turn suffered extreme mental anguish and emotional distress. States that the forced separation did include refusing communication, even eye contact with the minor child again, has likely taken its toll on the minor child and her mental health. 10. That after so many documented instances of defendant refusing to comply on a signed order, after so many documented instances of false affidavits given, along with the latest stunt pulled by the defendant on June 19, 2021, which not only resulted in the defendant not dropping the Justice Court complaint from February 2020 as agreed to, but defendant actually adding an additional harassing phone calls complaint, despite not one call being made between the plaintiff and defendant, and both her cell phone provider as well as the provider of the plaintiff know the truth as such. 11. The plaintiff is and has stayed current on his child support agreement, with the child support automatically withheld and paid directly to the defendant each month. 12. The plaintiff wishes to quash the withholding order and immediately halt all child support money to be paid out to defendant. The plaintiff understands his financial obligations to his child. However, the dangers of an individual continuing to go in contempt of a visitation order set forth by this court has progressed considerably past any type of warning from the court the defendant's counsel will likely argue for. Plaintiff would show that in order for a contract to be fully binding and enforceable, such as a contract for visitation rights and a contract for child support, there must be mutual consideration. Plaintiff lost the entire year of 2020, 12 plus months, of not seeing his minor child due to the defendant's lies. And that is time, no matter what, he can't get back. He's lost the majority of agreed upon time with his minor child in 2021, to include all summer vacation and Father's Day. As such, mutual consideration was catastrophically severed years ago and only compounded since. It's these reasons the plaintiff feels as an abrupt temporary end to child support paid out to the defendant is most certainly warranted, as this destructive behavior must be curbed, and it shouldn't be at the further victimization of the plaintiff by the defendant in this cause. Wherefore, all premises considered, this honorable court should have an obligation to send a deterring, punishing message to the defendant, along with defendant's legal counsel, whom have either assisted in the execution of her manipulation stunts, continuously waging an undeserved legal war on the plaintiff to stack overburden and stresses with the end goal of permanently ridding a caring father from his daughter's life. If the defendant's legal counsel did not assist in the execution of these stunts, at the bare minimum, defendant's legal counsel neglected their own ethical obligations all attorneys must maintain. To help curb future instances such as this, as plaintiff has suffered for 4 years at the hands of the defendant, plaintiff moves for this court to issue sanctions as allowable under MRCP Rule 11. Plaintiff moves that the defendant be required to pay an extremely discounted sum of $40,000, accounting for the time lost and the cost, injuries inflicted on the plaintiff's marriage and family life, and mental anguish both present and future bestowed upon the plaintiff at the malice hands of the defendant. The plaintiff respectfully moves that all costs of this court be taxed to Phyllis Crowder Kester and prays for any other relief in which he may be entitled to receive, both special or general. Respectfully submitted this 4th day of August 2021, Matthew Reardon, the Oxford Outlaw.